Chief Justice of India S.A. Bobde today cleared way for Justice N.V. Ramana to become the 48th Chief Justice of India after the current Chief Justice S.A. Bobde retires on April 23rd, 2021. Chief Justice of India S.A. Bobde sent the recommendation letter to the Ministry of Law and Justice recommending Justice Ramana to be the 48th Chief Justice of India. Justice N.V. Ramana will take the oath of office on April 24th, 2021. Supreme Court of India, by a notice today, also stated that the allegations leveled by Chief Minister of Andhra Pradesh Y.S. Jagan Mohan Reddy in the Amravati land scam case against Justice N.V. Ramana, former AG of Andhra Pradesh, the Malapatri Srinivas, and others were dismissed. It was an in-house procedure that was conducted, and the court maintained the details of the committee records cannot be made public. Chief Justice of India S.A. Bobde-led bench today heard an interim application by Association for Democratic Reforms seeking an urgent stay on the electoral bonds window, which is set to open from April 1st to April 10th. Advocate Prashant Bhushan, appearing for ADR, submitted in court that, in fact, Reserve Bank of India and Election Commission of India had also stated that electoral bonds may be used to fund illegal shell companies and be used for money laundering purposes. However, at this point, Chief Justice of India S.A. Bobde said that RBI in its report had also stated that these particular electoral bonds can be issued even in the demat form. Interestingly, the Election Commission of India, which had earlier opposed electoral bonds, today in court said that it does not oppose electoral bonds at all, and that if electoral bond scheme is stayed, that is going to open from April 1st to April 10th, then there might be an inflow of unaccounted money which is not accountable, and thus electoral bond scheme should not be stayed. Attorney General for India K.K. Venugopal submitted that all checks and balances are there in place to avoid any kind of money laundering or funding illegal shell companies, etc. Chief Justice of India S.A. Bobde at one point in the hearing also sought to know if at all the money which is generated from electoral bonds can be used to fund terrorist activities. At this point, Solicitor General Tushar Mehta stated that the electoral bonds can only be encashed by registered political parties under the Representations of People's Act. However, to this, CJI remarked that even political parties can fund protests and also cause violence. It has now asked the Government of India to look at its own level to see that the money generated from electoral bonds is not used for purposes that would create or incite violence in the country. The court reserved its orders on the interim application today. A Supreme Court bench of Justice Sanjay Kishan Kaul and Justice R. Subhash Reddy today asked former Mumbai Police Commissioner Parambir Singh to approach the Bombay High Court in a petition which seeks a Central Bureau of Investigation probe against the alleged corrupt malpractices by Maharashtra Home Minister Anil Deshmukh, as alleged by Singh in a letter to the Chief Minister of Maharashtra Uddhav Thackeray. Though Senior Counsel Mukul Rohatgi pressed for an interim direction from the top court, the bench of the two judges were not inclined to entertain the petition at this stage and instead asked the petitioners to approach the Bombay High Court even for a stay on the transfer order which ousted Singh from the post of being the Mumbai Police Commissioner from March 17th. Justice Kaul, in fact, noted in his Supreme Court order that the Prakash Singh versus Union of India 2006 judgment is often used periodically by counsels to occasionally suit their own respective purposes, especially since none of the directions that were enshrined in the particular judgment are really followed. Lastly, today was the day 8 of the Maratha reservation hearing, where a 5-judge constitution bench of the Supreme Court, headed by Justice Ashok Bhushan, was hearing a batch of petitions challenging the constitutional validity of the Maharashtra State SEBC Act, by which certain educational and employment quota benefits were being provided to the Marathas. Senior Advocate Shekhar Nafre for Tamil Nadu argued that Indira Sawhney case should be reconsidered, as it is extremely difficult to cull out as to what is the ratio in Indira Sawhney on the aspect of there being a 50% limit. There could be different perceptions as to the ratio in Indira Sawhney. Senior advocate C.U. Singh and Paramjeet Singh Patwalia defended the Gaikwad Committee report, which favored Maratha reservations. Singh also contended that even if a community is politically forward, it does not mean they are not socially and educationally backward. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court today tomorrow as well. And don't forget to like and share BharatBench.com.